Hello, and welcome to the Health Insurance Portability and Accountability Act of 1996 HIPAA refresher course, created by Shalane Ritchie, RHIA, with contributions from Karolina Austin, RHIT, and presented by the Stay Qualified. On our agenda today, we are going to review what is HIPAA, the purpose of HIPAA, privacy rule, HIPAA terminology, protected health information, examples of PHI, examples of information not considered PHI, uses and disclosures of PHI, authorizations, minimum necessary standard, telephone disclosures, ways to protect patient privacy, security reminders, notice of privacy practices, management, employees, and privacy officer role in HIPAA compliance, examples of policies, some scenarios, HIPAA enforcement, violations, and criminal penalties, and how to report a violation. So let's start with the basics. What is HIPAA? HIPAA is the Health Insurance Portability and Accountability Act. It establishes the national standards to protect individuals' medical records and other personal health information, and it applies to health plans, healthcare clearinghouses, and those healthcare providers that conduct certain healthcare transactions electronically. Under HIPAA, it establishes appropriate safeguards, sets limits and conditions on the uses and disclosure, gives patient rights over their health information, and also includes the 5 titles. Title I, Healthcare Access, Portability and Renewability. Title II, Preventing Healthcare Fraud and Abuse. Title III, Tax-related health provisions. Title IV, Application and Enforcement of Group Health Plan Requirements. And Title V, Revenue Offsets. Many people wonder, what is the purpose of HIPAA? HIPAA was established to improve efficiency by creating national standards for electronic healthcare transactions and code sets, unique health identifiers, and security across the healthcare industry. With these standards, it will help reduce the administrative burden, lower operating costs, improve quality of information exchange. The HIPAA privacy rule establishes national standards to protect individuals' medical records and other identifiable health information. It requires appropriate safeguards to protect the privacy of PHI and sets limits and conditions on the uses and disclosures that may be made without a signed authorization by the patient. It also establishes the rights that patients have over their individual PHI. Some of these rights include the right to establish who is allowed to access their individually identifiable health information. It gives them the right to revoke any signed authorizations, and it also gives the patients the right to access their own health information. Some HIPAA terminology that we will be using throughout our presentation, and terminology you may have heard, just don't understand exactly what it means in the healthcare industry. Protected health information, also known as PHI. Personal identifiable information, also known as PII. Treatment, payment, healthcare operations, known as TPO, uses and disclosures, authorization and/or ROI, release of information, minimum necessary, and notice of privacy practices, or NPP. So what is considered protected health information? There are a few rules that will help identify what protected health information is. Protected health information, also known as PHI, can be either written or oral. It can be recorded on paper, computer, or other media devices. It is information that reveals the state of a person's health. The information is individually identifiable. The health information that is individually identifiable and therefore PHI if it gives reasonable basis for determining the person's identity. So understanding what this is means if the information contains anything about an individual's diagnoses, medical condition, whether it is past, present, or future, and it can identify an individual. Other identifiers, which we will continue to review on the next slide, are identifiers that can individually identify that individual, meaning it is a personal identifier. It is unique to that individual, or it can identify an individual in a small group. So some of the examples are an individual's name, the elements of a date except for the year, telephone numbers, fax numbers, email addresses, social security numbers, and yes, the medical record number. Health plan beneficiary numbers, license numbers, vehicle identifiers, device identifiers, URLs, IP addresses, biometric identifiers including finger and voice prints, photographic images, all geographic subdivisions smaller than a state, and any other unique characteristic or code that could uniquely identify an individual. So looking over these examples, you could say that basically almost anything and everything could potentially be an individual identifier. And this is where many individuals tend to have a couple of problematic areas. One of the most common mistakes is the medical record number. Many individuals feel that because that medical record number is assigned internally to that patient through a database, that it is not considered PHI, whereas that medical record number identifies that patient. So when you're thinking about the identifiers, it doesn't matter if it's an internal number or code or an external number or code. It could be an identifiable of PHI. Some examples of information not considered PHI. Information in education records covered by the Family Education Right and Privacy Act. Employment records held by a covered entity in its role as the employer. A demographic report of the population served as long as names and identifiers have not been included, and information on services provided as long as it is not linked to individuals. Understanding uses and disclosures of PHI. Uses are sharing, employing, applying, utilizing, examining, or analyzing of information inside the organization that maintains the PHI. So when we discuss uses, that is within your organization, your hospital, your facility. That is information that you are sharing with your coworkers, especially if they have a need to know the information. Those are considered uses of PHI. Disclosures are any information being disclosed. So what that means is any information being released, transfer or provisional of access to PHI outside of the organization for other than treatment, payment, or healthcare operations. So a disclosure means you are sending information outside of your organization to another entity or to another organization. These would require a release of information or authorization signed by the patient for your facility to be able to disclose the information. Let's discuss the requirement for the authorizations, also known as release of information. So a release of information or authorization is required when you are disclosing information that does not pertain to treatment, payment, or healthcare operations. When you are disclosing information for marketing, fundraising, and medical research, for the release of psychotherapy notes, and in special categories such as HIV/AIDS, alcohol, drug abuse, or substance use disorder records. When you are dealing with any of these categories, you must have the patient sign an authorization or release of information. The special categories, when you are looking into those, these special categories are considered highly confidential categories. So HIV and AIDS, when you are releasing any information that contains anything, whether it's a diagnosis, treatment, medication that pertains to HIV and AIDS, the patient has to give consent to disclose that information to whom you are trying to send it to. And that is, they need to give consent, whether it is for treatment, payment, or healthcare operations. The other requirement is for alcohol or substance use disorder treatment records. Once again, if you are going to be disclosing anything that pertains to alcohol or substance use disorder, regardless if it is for TPO, treatment, payment, or healthcare operations, you must get a signed release of information authorization form by the patient. The substance use disorder and alcohol are mandated by a separate federal regulation called 42 CFR Part 2. And under that regulation, it clearly states that you may not use or disclose any information about the patient without a signed release of information form. And that includes for any providers, payments, or healthcare operations. You have to have one on file to be able to use or disclose the information. So an example may be you are an inpatient facility and you have a patient that is going to be transferring to another facility, maybe across the state. They're transferring to the east coast of your state, and you want to send their treatment records to their new facility. In order to do so, even though that new facility is going to be providing treatment, you have to obtain a signed authorization form by the patient to send those records to the new facility when you are pertaining to alcohol or substance use disorder. Any authorization is considered a legal document. So therefore, it must be in writing, okay? These are legal documents. When the patient signs the document, they must sign it knowing that they understand what is being requested. It has to be in clear and plain language. They have to have the opportunity to select what information they are comfortable with in sharing. And it also has to have language in the authorization form that the patient has the right to revoke the authorization at any given time. So under HIPAA, the patients always have the right to revoke an authorization. There are some separate stipulations on when an authorization can or cannot be revoked. One of those is if disclosures have already been made on a valid authorization, the patient can only revoke the authorization moving forward. They can't revoke it in the past. Who is authorized to access PHI? And this is a very common question in facilities with multiple staff members on salary or payroll. And not every staff member that works at the facility is authorized to access PHI. It all depends on what their role in the facility is and what their role or involvement is with the patient. So healthcare providers that are involved in the patient's treatment, such as physicians, nurses, counselors, techs, phlebotomists, laboratory personnel, radiology personnel, if the patient is getting some imaging done, those individuals are allowed to have access to the patient's PHI. The patient is also allowed access. That is one of the things under the HIPAA rule is it gives the patient the right to access their own health information. Anyone that is authorized in writing by the patient, all staff members that their roles and duties are necessary to carry out their responsibilities. So some staff members that may not be clinical or medical personnel are staff members such as your medical records specialist, your coders, your billing specialist, your performance improvement department, utilization review department. Those are individuals that do not really have a relationship or a treatment or conduct treatment with the patient, but they still carry out duties and responsibilities on the back end. In addition to those staff members, your business associates, they are allowed to have access to PHI if it is necessary to carry out their duties and responsibilities. So some individuals may have business associates that do their coding because you outsource it, or you have business associate agreements in place for dictation or transcription services if that is outsourced. Those individuals would have a need to access the information to perform their job duties and responsibilities. Minimum necessary standards. Minimum necessary is a policy that requires any person requesting or releasing PHI to do so in light of what information is needed to carry out the intended person of the request. So consider the following questions. How much information do you need to perform your job? When you are going to be requesting or releasing information, you need to ask yourself these questions. How much information is needed? 9 times out of 10, you're not going to request an entire medical record. As many people know, an entire medical record could be anywhere from 5 pages to thousands of pages. It really depends on how long the patient's been in treatment, how long you've been keeping the records. So it really all depends on what information you need to do your job. So if you are in a billing department and you need to request records um, from another facility because you are trying to do some physician billing, you're only going to request the records pertaining to the dates of service that that physician provided services to that individual. So you would not need the entire medical record. You would only need the specific dates of service that you are billing for. How much information does the requester need to perform their job? When you are releasing information, what are you releasing? Are you releasing an entire record? Are they asking for the entire record? What do they need to conduct their job? Now, we're not saying, you have to tell a doctor, no, you don't need this information to conduct your job. What we're saying is you want to question them. You want to ask them because sometimes they don't know what they're looking for. Every facility has different types of records. And when you speak to the different personnel, they might start saying when you are asking the questions, well, I really only need the treatment plan, the discharge summary, and the last 2 progress notes. That might be all that they really need, but they do not know what is contained in your medical record that you are trying to release. So you want to not only ask yourself the information, what do you need, but you want to also ask them, inquire, listen, you know, minimum necessary standards states that I have to limit the information being sent out. So what is it that you're really looking for? What is it that you really need? You can also, many facilities have a standard abstract record that they send out to certain entities. For example, one of my facilities I worked at, we had a standard abstract for treatment facilities. So when we sent a patient to another treatment facility, we had a standard abstract that we would send. And that abstract included, of course, they were a behavioral health entity. So it included their psychiatric evaluation, their most recent drug screen, the 5 most recent progress notes, their medication administration records, their treatment plan, and any type of medications that they are being sent with. And if it was available, we also included the discharge summary. So we had a standard abstract that most of the facilities, that is all that they needed. What we did was we networked with all of our local facilities, and we sat down and we communicated with one another and created a standard abstract that all the facilities in our area would use. That way it was minimum necessary, it met the requirement. We weren't sending a whole bunch of nonsense information that they would have to go through later on. It was time consuming from them, it was time consuming for us. So as a community, we created a standard abstract. You also want to limit your workforce access to PHI. I touched on this briefly, but your workforce members, who should be accessing that information? Should a tech have the same access as a nurse? Should a nurse have the same access as a counselor? So those are some of the questions you have to ask yourself. What is their role? What do they need to access? How much of the information should they be accessing? An example is you shouldn't have an individual on your janitorial staff accessing patient information. It's not part of their duties. It's not part of their roles. They shouldn't be accessing that information at any given time. Whereas, nurses, you might have a nurse from one unit float to another unit, and they might have a need to access that unit's information because they are going to be providing coverage or assistance. There are a few exceptions to the minimum necessary standard. One of them are law enforcement and others required by law. But you also want to make sure that the minimum necessary standard is meeting the criteria for other regulations as well. And you really also want to look at your state statutes because different state statutes also have different regulations. And once again, if you are dealing with behavioral health, substance use disorder, those have their own separate regulations versus regular HIPAA regulations that are covered for your basic records. Telephone disclosures. Telephone disclosures are probably one of the areas that tend to get entities into a little bit of trouble, and there's a little bit of conflict depending on what type of entity you are and what type of treatment you are providing. Telephone disclosures really need to be limited to emergency medical situations. You should be very careful when you are disclosing information via the telephone, also disclosing information to individuals verbally. You should also limit the disclosures to lab results and tests, and you should be always asking for two patient identifiers. When you are disclosing information over the telephone, you really, really want to be careful to make sure you know exactly who you are talking with. Um, Now, there are situations where, you might send a patient to a facility and they need a verbal disclosure from you. That facility might need a verbal disclosure from you. Maybe they can't read the last medication or dose on the record that was printed and sent over to them. You always want to verify the person on the other end, and you always want to have two patient identifiers. Um, the other conflict is sometimes the patients will call, or if they are at an inpatient facility or they are in your hospital and they just had surgery and they're going to be with you for a little while, family members. Family members will call to check up on their loved one or want to find information out about their loved one. You really, really, really want to be very, very careful when you are dealing with verbal disclosures over the phone. Um, One thing that I put into practice at one of my facilities, because during COVID times, we could not have visitors, and our patients wanted their family members to be able to get information pertaining to their health from our nurses or physicians directly, especially since they weren't able to come to our facility during COVID times. So we came up with a code word or number that the patient would create, and they would write that down on an authorization form. We had a special authorization form created, and it gave us permission to verbally disclose information to the listed individual on the authorization form. And it had specific information we were allowed to disclose. And we wrote in a code word or number. And we stressed the importance that the patient provide that code word or number with the individual listed on the authorization form, because when they called, we were going to request that code word or number. And that is one way we were able to verify that the individual that was on the release form was the individual we were talking to on the phone. We did ensure that the patient understood that they should not share that code word or number with anybody else but the intended individual. And we also made sure that the individual listed on the release would not share that code word or number with anybody else in their family and their inner circle, because that means if they call, anybody could call and pretend to be them, because we always went off of the code word or number, and we asked the telephone number, the address listed on the signed release, and we asked certain information. You also want to document all phone requests, and you also never want to leave confidential information on a voicemail unless the patient has requested that you do so. If the patient requests that you leave something on a voicemail, you want to get that in writing. I cannot stress the importance of get it in writing. Always ensure if the patient is making a request or a special request, get that on a signed release of information, because that will protect not only you, but it will protect the patient. So if you work at a facility that, might have units or several patients at one time, how do you protect the patient privacy? You want to make sure that you are safeguarding the information. So do not leave PHI out in the open. If you are a paper facility and you have a nurse's station, if a patient walks up to the nurse's station, there should be no PHI on the nurse's station where they can read it, see it, flip pieces of paper over if you have to protect the privacy. Access only minimum necessary information to do your job. So ask yourself, what information do I need to know? If you are working in behavioral health care and you are a nurse, do you need to read the progress note that the therapist or the counselor had with the one-on-one session of that patient? Is there information in that that you need to know to do your job? Are you going to provide services to that patient based off of what is stated in that note? So you need to ask yourself these questions. What is it that I need to know to do my duties? If you're a nurse, you may not need to know what was said during the one-on-one therapy session. Because remember, sometimes our patients are comfortable with certain people and they open up to them versus others. And we don't want to break that trust. Um, you want to minimize patient conversations in open areas. So when you have a lot of patients in one area, you want to minimize the conversation that you have with the patient in open areas. And an example I like to use is a medication window. If you are a facility and you have patients that come up to a window to receive their daily medications, you want to minimize the conversations at that window. If a patient has a lot of questions, if they have a lot of concerns, it's always best to let the patient know, listen, do you mind if I go ahead and get everybody else medicated this morning or give them their meds? And then you and I can go into a private area and have this conversation, because you don't want their information to be disclosed to everybody else who's standing in line. Use headsets when talking on phones. Don't, put a patient on speaker or put a doctor on speaker, because you never know who they are going to be discussing information on. Read your policies and ask clarifying questions. Most facilities have policies and procedures in place that can answer many of your questions. And if the policy or the procedure is not clear, ask those clarifying questions, ask those hard questions. Say, listen, I read the policy and procedure and I'm a little confused. I don't understand. Just ask for that clarification. And last but not least, report any suspected HIPAA violations. You are the frontline workers. Your privacy officer or risk manager is not on the floor every day. They don't interact with the patients every day. They don't see what's going on. So you guys are the frontline workers. You guys are the ones that need to kind of inform the privacy officer of anything that may be suspected as a HIPAA violation, even if it's not a HIPAA violation. As a privacy officer, most of the reports I get are what I consider near misses. So 95% of my incident reports are considered near misses. They are not actual HIPAA violations, but they are things that could have potentially led to a HIPAA violation. So that data actually gives me resources and material to conduct trainings with staff to ensure I cover those topics and cover those areas that are considered near misses. So it's okay to report it. If you see something, say something. If you're not sure If it is a HIPAA violation, you just really do not know, report it to your privacy officer. They're going to be the ones who conduct the investigation and determine, is this really a HIPAA violation? Is it a near miss? And they're going to take it from there. So do not be afraid to report those to your privacy officer. Security reminders. Rule number one, sharing of passwords is prohibited. Everybody has their own unique username and password if you're dealing with an electronic health record. And those permissions that are assigned to that unique username and password are for specific roles. So we discussed the importance of your role and the need to access information. Not everybody has the same level of permission or access in an electronic health record. A counselor may not be able to access everything that a doctor can. The billing department may not be able to access everything that medical records can. So you want to be very, very careful with your username and passwords. Never share them. That is prohibited. That is a violation, and you really want to make sure that no one gains access to that information. Not only is it important because certain permissions are given to see certain types of PHI, but certain permissions are given to be able to manipulate the medical record or the electronic health record. So a medical records director may be able to delete certain things, they may be able to merge certain things, and you don't want somebody who doesn't understand or know how to do that going in under your access and completely destroying the electronic health record. So never share passwords, never, ever, ever. Your workstations, they should be positioned so that the displays cannot be seen by unauthorized individuals. If you have a workstation and you know patients or clients or individuals are going to be walking by it and they can see it, you might want to invest in some of those privacy screens. They have privacy screens where you can't see the screen from certain angles. So you want to look at your workstation. If you have documentation, paper records, you want to make sure that paper records are not laying face up where others can read it. If they're coming up to your desk, lock your computer or your laptop when it is not in use. Control Alt Delete. Control Alt Delete. Always lock your workstation. It's not only to protect your username, access, and credentials and permissions, but it also prevents others from getting on to the information. You don't know who would do something. If you upset one of your fellow coworkers and they're feeling a little devious, they could easily go onto your computer and send an email to anybody they want. And it could get you in a lot of trouble. So always, always, always lock your computer or laptop when not in use. If you are traveling with a laptop, never leave it in the open view of your car. You want to always lock it in your trunk. I recommend never leave your laptop overnight in your vehicle, whether it's the trunk or not. You always want to bring those electronics in. If you do not have a trunk, you want to put it in a bag and maybe slide it under the seat, put something over it to cover it, or just take it with you. Do not save PHI on unsecured devices, such as your personal Google Drive. You do not want to save PHI on personal drives, USBs, or anything of that nature. You always, always, always want to save it on an encrypted device. So if you are going to be, working on maybe accounts or something like that, and you need to save the information, you can get a USB drive that's encrypted. That way, if you save information on it, if that USB drive becomes lost or misplaced or stolen, nobody can access the information because it's password protected. Um, Follow your faxing policies. Always, always, always verify the fax number. One thing that my staff are encouraged to do, and it's part of our processes, is even if we receive a fax from an entity requesting records, and on the fax cover sheet, they have typed in their fax number for us to return the information to, we always call that entity and verify that that fax number is the actual correct fax number. Sometimes staff members get in a hurry, they mistype fax numbers, they write the wrong fax number. Anything can happen. They've recently changed fax numbers and they didn't remember because they've already had 10 pre-printed blank fax cover sheets. So always call and verify that that is the correct fax number. And emails. Anytime you are going to send PHI via email, it has to be encrypted. Many companies now have programs that automatically encrypt your emails if you type a specific keyword into the subject. If your entity or facility does not have those programs, you can also encrypt the documentation. You can encrypt the PDF. You can encrypt the Word document, whatever it is, whatever type of format you use, you can always encrypt the actual document. And when you send the email, send the password to unlock that email in a separate email. Don't send them together. So always send them separate. Password separate, and then records. Notice of privacy practices. HIPAA requires all healthcare providers to provide the notice to patients on how their information will be used. So prior to providing services, all patients must receive the notice of privacy practices. This document informs the patient of their rights related to their own PHI. Not only must the patients receive a hard copy of the Notice of Privacy Practices, it must be posted on your facility's website. If you are giving them the paper copy, you must also obtain the individual's acknowledgement that they received the notice and retain that acknowledgement in their medical records. I cannot stress the importance of this. If you go through any auditing agency, whether you are getting audited for Joint Commission, ACA, DCF, CARF, the first thing an auditor has always asked me as the medical records director compliance officer to show them is the notice of privacy practices. They wanted to see what we were giving patients. They wanted to see it posted on our website, and they wanted to see one in the chart. They wanted to see the acknowledgement of receipt in the patient's medical record. So they automatically always went and looked for that first before they even started looking at any of our other legal documentation or other legal consents. It was always the notice of privacy practices and consent for treatment that they always wanted to see first. If changes are made, a new notice must be given. So if you are currently making changes to your notice of privacy practices, or a patient is coming to your facility and they've been coming to your facility for many, many years, and you update your notice of privacy practices, you have to provide that patient with a new notice. They have to receive the updated notice, and they have to acknowledge that they received the updated notice. One of the practices we have in place at our facility that I currently work for is every year at their annual review, every patient will receive a new copy of our Notice of Privacy Practices, and they will acknowledge that they received a copy of the Notice of Privacy Practices. So if the patient's been with us for 15 years, they get one every year. So they will have 15 of those. So it doesn't matter if it's the same notice that we had the year before. To ensure that we capture everyone, our practice is at the 1 year mark of their annual review, we automatically get them to get a new notice of privacy practices, and we have them acknowledge that they received it. It's also a good time for the patient to review any of the signed releases they have on file. It lets them ask questions. Maybe they want to add some releases. So this during the annual review is a good time to capture those. The right to restrict uses and disclosures. So different facilities have different practices, different privacy officers do different policies and procedures on this. And it also depends on if you are mandated by any other federal regulations. But you want to ask them to complete a request for restriction on uses and disclosures. You want to have a designated form or a designated process. If you don't have a designated form or process, that's something you want to look into creating. If you're not sure if your facility has a form or process, you really want to ask your privacy officer what that process is. The privacy officer will decide to approve or deny the restriction, and they will notify appropriate staff. Patients may not request restrictions if the disclosure is permitted by law or emergency purposes. So if you have a patient who does not want to disclose certain information to law enforcement officers, for example, some states have laws that if an individual comes into the emergency department and they are the victim of a gunshot wound, that must automatically be reported to law enforcement officers. So therefore, the patient would not be able to restrict that disclosure. They cannot tell the facility workers, please don't call the police because of my gunshot wound. So you have to look at your state restrictions as well. They may request restrictions to family members, staff, or other entities. So if they do not want their family members gaining access to certain information, certain staff, or other entities, then they can put a restriction on that. So once again, you want to get that restriction in writing, and the privacy officer will decide whether they can approve or deny it, and they will notify the appropriate staff. And restrictions can be terminated by the patient at any time, but must be in writing to the privacy officer. So one of the processes we have at our facility is if the patient puts a restriction, let's say they don't want their significant other finding out information about them, and they put the restriction that they don't want their significant other accessing their information. They put that restriction in writing. The privacy officer, we will notate that in the record. We will honor that restriction as long as we can. And then if they want to terminate that restriction, they have to do two things. The first thing they have to do is they have to sign a release of information form, and they will put their family member on that release, and we will have that release of information on file. The second thing that they will do is we have a form terminating the restriction. So at the bottom of all of our right to request restriction, on the bottom of our form, it actually has a spot where the patient can sign and date to terminate the restriction. Now, if you are an electronic record, your forms may be a little different. You may have two forms, but regardless, we require them to not only sign the bottom of that form, and we also require them to fill out a release of information, allowing information to be disclosed to that individual that they had the restriction on. The right to an accounting of disclosures. The patients have the right to request an accounting of disclosures, and this is under HIPAA, and this applies to every patient as part of their rights. They are allowed to get the accounting. Exceptions and potential areas where these disclosures will apply are the request must be in writing to the privacy officer. So under HIPAA, the request must be in writing, and it has to go to the privacy officer for them to receive an accounting of disclosure. Once again, your state may say something different. So you need to look at your state statutes In addition to, if you're dealing with behavioral health or substance use disorder records, you also need to look at what the requirements for the accounting of disclosure is for those, because they can differ. The account must account for the past 6 years of disclosures. And specifics to be provided are the date, the name, the PHI disclosed, and the reason for the disclosure. So those are the elements that must be provided when you are providing an accounting of disclosures to the patient. It has to have the date that the information was disclosed, the name to whom it was disclosed, and what PHI was disclosed in addition to the reason for the disclosure. You cannot put entire medical record for PHI disclosed on every accounting of disclosure. That does not suffice. They want a detailed account of what was disclosed. Right to inspect, copy, and amend. The patients have the right to inspect and or copy their information. This is going to be done through an authorization for release of information request. If they want to receive a copy, then they will fill out a release of information and they will get a copy of their record. The request to amend must be in writing, and your privacy officer should or would have created a form that the patient fills out to have an amendment request be made. It will be the privacy officer that will make the determination if the request is going to be approved or denied. If granted, an appointment can be made if needed. The medical record director, the medical director may be notified. So it all depends on what they are requesting to have amended in their record. Personally, I have received some of these requests, and I can tell you from a professional standpoint, if the request has anything to do with medical documentation or diagnoses, I always get the medical director involved. So if the patient is requesting to change their medical information or their diagnosis, the first thing I do is I make a copy of the medical record that is requesting to be amended, and I sit down with the medical director and we go through the information, and it will be up to the medical director whether or not that information can be amended. If they are requesting changes such as demographic information, certain information that doesn't require the medical director, depending on the information, I may or may not grant it. And if it's not granted, then I have to provide a reason in writing to the patient within 60 days of why the request was not granted. Management role in HIPAA compliance. So the management's role in HIPAA compliance is to understand the rules, regulations, and obligations under which your organization operates. Establish systems to secure protected health information, distribute notice of privacy practices, and execute business associate agreements. Communicate the expectation to staff regularly. Review HIPAA rules with staff annually and maintain documentation of all reviews. I will say that at our facility, we conduct semi-annual trainings. So every 6 months, we have a HIPAA training update review with all of our staff, and it's just a good refresher because we take the privacy and security of our records and documentation very seriously. So to me, a year is a little bit of a stretch for people to remember critical information. So therefore, we do ours every 6 months. HIPAA only requires you to do it once a year, but our facility, as a best practice, we conduct it every 6 months, semi-annually. Management's role also includes enforce the non-retribution policy to ensure that no retaliation action is taken against anyone for reporting a violation. As the privacy officer at our facility, if I am informed of a potential HIPAA violation or breach violation or any type of incident relating to HIPAA, I make sure that there's going to be no retaliation against the individual reporting the violation. I try to keep the individual's name who reported it out of my investigation. That way I can ensure there's going to be no retaliation. And the management's role in HIPAA compliance, last but not least, to sign up for the OCR privacy and security sessions. They have the different, HHS provides the different sessions for the professionals. You can look at their website. You can look at the list. They have case studies on there. Keep up to date with things that are happening out in the world of, HIPAA compliance. I personally receive emails from HHS when there have been violations and fines at other entities, just because I want to see what other entities are getting fined for. I can take that information and create trainings within my agency to make sure, hey, this is a good refresher, or this is something I need to touch on because other facilities are getting dinged on it. So it's a really, really great tool to use. What is the employee's role in HIPAA compliance? So the employee's role is to review the policies and procedures and understand how policies and procedures pertain to your role. Once again, a nurse may have a different role than a tech, and a tech may have a different role than a counselor. You want to be very familiar in those roles, those policies and procedures, on what you can or cannot do when it comes to uses and disclosures of PHI. You want to become familiar with the notice of privacy practices and be able to communicate the contents and answer any questions about it. I don't know how many times I've seen, a patient asking someone in admissions, well, what does this mean? What does this mean? And the admissions person not even know what it means in our notice of privacy practices. So therefore, make sure no matter what your role is you understand the notice of privacy practices and the contents in it, because the patient may grab you, they may grab a nurse, they may grab an administrative person. You never know who they're going to grab and ask that question. So become familiar with it. If you don't understand it yourself, ask the privacy officer, because if you can't understand it, then that means our patient can't understand it. So therefore, the privacy officer may need to reword or make it a little bit more clear in what the notice of privacy practice is. Seek assistance if unclear. If you're unclear about something, if you're not sure if you can release or disclose information, if you're just not sure, always, always, always ask for assistance. Reach out to your privacy officer, reach out to your medical records department, reach out to those individuals who are very familiar with HIPAA rules and requirements. Even if it pertains to other statutes, if you are dealing with substance use disorder treatment records, that's a whole nother level of needing to understand requirements. Get with your medical records team, get with your privacy officer, ask those questions. Trust me, as a privacy officer, I would rather a staff member ask me 100 questions than to go on their own and do something and then create a breach or have an incident, or whatever the case may be, because then number one, that's more work on me in the long run, because then I have to open up an investigation, which takes time, and you have to do this, then you have to Once your investigation's done, you have to either report it or not report it to HHS, depending on where it falls into. Then you have to do some type of training or education to the staff members, sanction levels, all of that. So it's more work for me in the long run if the staff members are afraid to ask me the question and I can give them the correct answer. I would rather someone ask me the question and I can give them the correct answer for rather than them do it on their own and do it wrong. And as always, report any violations. If you see something, say something. Make sure that you are reporting those violations, even if you don't know if it's a violation, if you're unsure, you just think something's wrong, just report it. I would rather do 100 investigations on things that are not considered breaches and are near misses than to do 5 investigations on true breaches. So if you see something, say something. It's okay. The privacy officer's role. Many of you have probably been asking yourselves these questions. Who is the privacy? What is a privacy officer? What is their role? I had no idea who our privacy officer is, and I'm going to clarify a couple of those questions you probably have playing in your head. So under HIPAA, every facility is required to establish an individual who is called the privacy officer. Most of the time, your medical records director is going to also be your facility's privacy officer, but that's not the case in every facility. So if you do not know who your privacy officer is, it's a good time to go and ask, who is our privacy officer? You legally have to have an established privacy officer. Some of the roles that a privacy officer does within the facility is they work with legal counsel, leadership, and management to ensure organizations maintain the appropriate privacy, consent, and authorization forms, notices, and other materials. So they are working hand in hand with your facility's attorney, or if they have someone else on legal counsel, they're working with leadership and management staff to ensure that those consent and authorization forms, notices, and other materials are accurate and meet the requirements of all the federal regulations, all the statutes that your organization has to follow. And sometimes they have to also ensure that it meets the requirements of your funders or your credentialing agencies. They also establish and administer a process for receiving, documenting, tracking, investigating, and acting on all complaints concerning privacy policies and procedures. So anybody that has a concern about the privacy policy or complaint about their information being misused, so they're the ones who handle those. They oversee, direct, deliver, and ensure the delivery of privacy training. So you have probably seen your privacy officer at one point or another in your career because he or she would have conducted a training or presented a training, or you may have heard their voice during a presentation that may have been online. So they oversee, direct, and deliver all of your privacy trainings. They monitor compliance with privacy policies, including periodic risk assessments. They review and update policies and procedures at your facility pertaining to privacy at least every 3 years. Most facilities do annual reviews. I know at our facility, we conduct an annual review and update of our privacy policies every year. We do it annually. They provide human resources information to address issues and potential discipline related to employee failure to comply with privacy policies or applicable laws. And they are the ones who maintain copies of all the business associate agreements. So that is the role of the privacy officer at your facility. Your privacy officer may also be your compliance officer or they also could have other duties as assigned. Once again, many facilities have a privacy officer that has another title as well. The privacy officer also maintains current knowledge of applicable laws and state privacy laws. I cannot stress this enough. Your privacy officer is going to be the one that ensures that if there are any changes to any of the federal statutes that your facility has to follow, or even state statutes, they are the ones who have to update them and ensure all of the staff members at the facility are aware of the new changes. Many laws are changing very rapidly and very fast. HIPAA, it was getting updated. It's in another stage of being actually updated. There are pending updates right now that we are waiting for approval. We don't know whether or not they're going to go through. They just had the public's comments inputted on potential changes. 42 CFR Part 2 recently went through an update in 2018. There are also additional updates that are pending, and we are waiting on those updates to be released. So laws are continuously changing, especially in the mental health and behavioral health and substance use disorder field. Those laws are ever changing. As the culture changes, the laws are changing. They also investigate, document, and report HIPAA breaches internally. They report HIPAA breaches to the HHS or the Office of Civil Rights, OCR. They cooperate with the Office of Civil Rights and other legal entities in any compliance reviews or investigation. And they act as the point of contact for receiving, documenting, and tracking complaints concerning privacy policies and procedures. So some examples of policies that would relate to HIPAA are confidentiality of PHI. If you go into your policies and you look for the verbiage confidentiality of PHI, record confidentiality, documentation confidentiality, the word confidentiality is probably going to be your keyword in searching for HIPAA level policies. Disclosures of protected health information is another good one. Employees' access to records or their own records, uses, disclosures, and requests for protected health information, minimum necessary, email encryption, de-identifying protected health information. Those are some examples of names of policies or certain policies that you should have at your facility. If you are using electronic records, you should have an email encryption policy. If you're not sure how to encrypt an email, I highly recommend you look at your policy and procedures. I guarantee your facility will have one if you are sending or receiving electronic records. So it should be under like an email encryption policy or something of that nature. So let's review some scenarios. So scenario 1, while working on coding outpatient visits, you come across a visit of someone you know. What should you do? Give you a couple of seconds to think about that. So the correct answer is you should turn the visit over to your supervisor or trade with your coworker. So it's very, very important that if you come across information of someone that you know, you need to alert your supervisor. If you are working in an electronic health record, most of the time locks can be put in place. Once again, I go back to your user access roles and permissions. Your username is unique to you. In an electronic health record, your IT department should be able to go in and lock you out of a record that you should not be seeing. So if you let your supervisor know, they should be contacting the IT department and saying, hey, I need to ensure that this employee cannot access this record. So that goes for family members, anybody you personally know. We're all going to come into contact with people we know, especially if we live in a small community. So you want to make sure that you are very honest and truthful and just let your supervisor know, listen, this person, I know them personally. I can't access their information. So therefore, you can go in and have a lock put on to where if you are just looking at a medical record number, you don't have to memorize that medical record number. If you put it in, nothing's going to pop up. It's just going to say you are unauthorized to access this record at this time. Scenario 2, you see someone you know at a clinic or hospital site where you work. What should you do? I'll give you a couple of seconds to think about that. So you should not stop to ask them what they are being seen for. I know many of us, when we see our friends or loved ones at a facility, we want to run up to them and, ask them, is everything okay? What's going on? If you see somebody at your facility that don't walk up to them and ask them what they're being seen for. Once again, that is a conversation you can have on the outside in your own private setting, but not at work. Um, Keep conversations minimal and private. If you know somebody on a personal level, you should not be involved in their care or treatment. You should be notifying a supervisor and getting somebody else to take over, because you should not be accessing that information. You shouldn't be having knowledge of what's going on. And you never know how comfortable the individual may be knowing that you have access to that information. So it's very important that you do not access that information and continue your job duties as usual. So working in the substance use disorder field, it's very common that I see individuals that I may know through an acquaintance or, from certain events out in the community. And when I see those individuals, number one, I don't want them to feel uncomfortable because they may not want me knowing that they are receiving treatment. So the first thing I do is I immediately notify my supervisor. That way I can get my access restricted. Um, Number two, a lot of times I will ask my supervisor to go and speak with them to let them know that, number one, my access has been disabled. I won't have any access to their information to make them more comfortable, especially if they know that I've seen them. So, sometimes I'll ask my supervisor, do you mind going and talking with them to ensure that they're comfortable coming here because they saw that I saw them walk through our door, and I want to make sure that they are getting the treatment they need and they are not worried about me having access to any of their information. And please let them know that I'm bound by confidentiality, so therefore I cannot go and discuss them walking into our facility with anybody else. So, it's okay to have your supervisor have those conversations. Scenario 3, social media do's and don'ts. What should you do? So social media has become a little bit of a nuisance in the privacy world. We all love our social media. We all love Instagram, Twitter, Facebook, TikTok, Tumblr, whatever, you name it. Most of us have one social media platform or another. I personally, number one, have all my social media platforms set on private. So if somebody Googles or finds my last name, if they go onto my Facebook page, number one, they're not going to really find it. Number two, I don't have the organization that I work for listed on my social media. And number three, they can't friend request me. So I keep my social media private and I don't accept any friend requests from patients or whether they're former, current, or anything of that matter. I don't accept those friend requests. Um, so you want to be very, very careful with your social media. I personally, once again, have mine set on private. I have a private Facebook account. My name is not the name that I use at my job, so it's hard to link me to my Facebook account. Also, you don't want to post on behalf of your organization unless you're given the authority to do so. So speak with your organization. If they want you sharing their Facebook posts on your Facebook platform or whatever it may be, you really want to get their permission. Um, when you're posting information, you don't want to identify yourself as working for an organization when posting personal opinions. Um, as a hiring manager, when I am interviewing staff, I'm not going to lie. I go and look at their social media. If it's not private, I go through it and see, what they're posting. Are they posting, things that don't meet our code? Are they posting things that are against our mission or our values? If they're posting certain things out there, do I really want them to work for our organization? Um, for example, we had an applicant who um, was looking for employment at our facility, and our facility is really big in the LGBTQ community. We help a lot of the individuals out in the LGBTQ community. We are advocates for them. And when I went on the social media post of the individual who was applying to our facility, they were very anti-LGBTQ. So looking at the posts and knowing what our company or our organization stands for, they weren't going to be a very good fit. Um, so you want to be careful what you post on social media because that is open to the public and anybody can see that, especially if your information is not set on private. As a privacy officer, I will tell you be very, very careful on what you share on your news feed. So for example, if you are on Facebook and ABC News pops up on your news feed and it says, for example, Joe Schmo, 54 of Clearwater, Florida, stabbed and killed 15 people last night. You don't want to share that to your newsfeed and put, oh my God, he was just at my facility a week ago. So you want to be very, very careful of what you are sharing, especially when it's news articles, because you could be indirectly confirming a person being a patient at your facility. So HIPAA enforcement. So the Health and Human Services, also known as HHS, and the Office for Civil Rights, OCR, is responsible for enforcing the privacy and security rules. So they issue individual and organizational sanctions. When you submit your violations to them annually, they review them, and if the violation meets the criteria that they feel is necessary, they could impose a sanction against your facility or against an individual. If HHS comes knocking on your door to do an internal investigation, that's not good either. They can also give civil penalties, which results in fines typically, and they can enforce criminal penalties, which could usually be fines and jail time. You can also look at the enforcement highlights of the hhs.gov website, but if you're following your policy and procedures and you are, you know, catching potential violations, you really shouldn't fear, these sanctions or anything of that nature. Um, can they happen? Absolutely. Will they happen? They could. Um, I've worked for a couple of organizations and we haven't, thankfully, knock on wood, we haven't had any of these sanctions or penalties or fines or anything. But you just really want to read the federal statute. You really want to educate yourself. Ask other individuals. If you are a new privacy officer, reach out to other privacy officers in your community and ask them, hey, could you help me with this? We're all willing to help one another. So when I talk about violations, there are 4 tiers. So HHS and OCR have a tier system, tier 1, 2, 3, and 4. So tier 1 is typically a lack of knowledge. Um, so it's a minimum violation of $100 per violation, maximum penalty per year could be $25,000. And maximum penalty per violation could be 50,000. So lack of knowledge, those are typically your tier 1. Your tier 2 categories are reasonable cause. They go anywhere from $1,000 to $100,000. Willful neglect corrected, that could be $10,000 to $250,000. And willful neglect not corrected, those could range from $50,000 to 1.5 million. So this is why I say it's very important to notify your privacy officer of anything that could potentially be a concern for a HIPAA violation. Um, because once they conduct their investigation, they will determine, where it could fall, tier 1, 2, 3, or 4, the risk for the violation, the cause. If it can be corrected, they will do what they can to get it corrected. Because when they report these, this is the information that HHS uses to impose any type of sanctions or violation fees. This is not to say that the individual staff member is going to be charged these sums, but once again, this is why your privacy officers will really preach that they really need you guys to do breach reporting to them. So criminal penalties, there are 3 tiers. Reasonable cause or no knowledge of violation. It could be up to 1 year in jail. Obtaining PHI under false pretenses could be up to 5 years in jail. And obtaining PHI for personal gain or with malicious intent, it could be for up to 10 years in jail. Some examples that could fall under these would be, sending information unencrypted for tier 1 um, to an entity that shouldn't have received the information. Typically that's not going to be 1 year in jail, but depending on the circumstances, it could be. Obtaining PHI under false pretenses. An example of that could be saying that you are a nurse at a facility and you need records from another facility because the patient has transferred to your facility. And that's not the case. You just wanted records on a certain individual, whether it was a family member or significant other or friend, and you obtained those under false pretenses. Or obtaining PHI for personal gain or with malicious intent. That could be for anything, obtaining PHI on a celebrity. Maybe you have access to PHI on a celebrity and you sold that information to TMZ. That could be malicious intent or for personal gain. So those are a couple of examples. So how to report a violation? Always check your policy and procedures. You should have a policy and a procedure in place on how to report violations and to whom to report them to. You're going to talk to your immediate supervisor. You're going to contact your privacy officer, security officer, and compliance officer. You're going to fill out an incident report. And then your privacy officer will also conduct an investigation. And then you're going to file a complaint at hhs.gov. You don't want to file a complaint if you are already going to your privacy officer. So filing a complaint should be your last resort. That means that you have talked with your privacy officer, you've talked with your immediate supervisor, you've talked with other people at your facility, and they have not done anything to improve um, the standards or whatever that you have a concern or a complaint on. But always go to your facility first. If things are not getting handled, then you want to escalate it up. So in conclusion, HIPAA is a law. It is a federal law, and facilities have to follow it. It's a federal regulation. You have to make reasonable efforts to protect information in any format, whether it is verbal, written, paper, or electronic. It doesn't matter what format it is in, you have to make reasonable efforts to protect that information. Be aware of policies that were created to meet HIPAA compliance. So be aware of your policies and procedures. Read them, understand them, ask questions, know your role. What is your role at your facility? Ask yourself, what if this was my medical information? How would you feel if this was your medical information? Ask yourself those questions. For more information, you can visit the HIPAA news release and bulletins. You can look at the OCR guide on HIPAA, COVID-19 vaccinations in the workplace. You can look at the OCR guide on HIPAA and disclosures of protected health information for extreme risk protection orders. There's plenty of information out there. I encourage everybody to do some research. And there are also chat rooms on in those social media groups. You have Facebook that you can have groups in, and there are some groups that pertain to HIPAA and privacy, and people post comments in there and ask questions, and it's a lot of different level individuals that are in those groups. For a list of our resources pertaining to this presentation, please turn your attention to the slide. Once again, you can find us online at www.the-qualified.com. You can also follow us on Facebook and Instagram, The Qualified, or @2qualified, LinkedIn, and our YouTube channel. Thank you once again for joining this webinar presentation on HIPAA and the requirements of HIPAA privacy practices.